welcome to my seminar for seniors and powers of attorney. So today we're going to talk about powers of attorney that's going to fit your needs. But first, let me introduce myself. I am Cherie Tucker. I am the founder and owner of Tucker Legal Services. I have been licensed to practice law since 1991 in Arkansas and 1992 in Missouri. So I started out a long time ago. I took a little hiatus and taught some classes, and I'm back full-time in the practice of law. My main focus in my law firm is estate planning and elder law. So I do a lot of work with senior citizens, and I encounter different needs that the seniors go through medically and health-wise. And I also do a lot of work with people who have disabilities and need special needs trust. So that's a little bit about myself. Okay, so this evening we're going to talk about powers of attorney. We're going to discuss financial, healthcare, and the advanced healthcare directives. And I will try to get to your questions that you wrote out for me at the end of sections here today, all right? So let's talk about powers of attorney, what they are first. So powers of attorney are three important documents: the financial, the healthcare, the advanced healthcare directive. The powers of attorney allow a person to nominate or designate an attorney in fact, or you could think of that person as an agent, okay? And the person stands in your shoes to make decisions. Now, oftentimes, when a young person 18 years of age becomes an adult, they encounter circumstances that parents would usually normally have stepped in and helped them with. But at 18, the adult age makes it a little more difficult for other people to stand in and take care of financial or medical decisions, all right? Well, people usually don't think about these powers of attorney and they get married. And yes, a married person, there is a presumption that your spouse can take care of a financial decision or a medical decision and make end-of-life decisions. There is a presumption. But not having a document in place, not designating a person to act as your attorney in fact, may cause unpleasant circumstances to occur requiring some legal intervention. So why do we need these powers of attorney? Okay, so first of all, without them as a single person, even if when you're a senior citizen, okay, and you don't have anything in place and something happens, who is going to go to the bank to take care of your bills? Who's going to pay your bills online? Who is going to make sure that medical decisions are being followed? When you don't have these documents in place, family fights can happen. If you have no family, I mean, in today's society, there's broken families. There's older people who are alone, live alone, and there's no one, maybe some close friends, to step in and help. But what if you just have a close friend? Do you think that bank institutions or hospitals are going to allow that friend access to records? Answer: no, not really. Most likely not. Then what happens if you have incapacity and nothing is in place? That documents to be filed in court, in probate court, asking for the court to appoint a guardian or conservator. If there is no one who can serve as a conservator, the state will become the conservator over your finances. So the financial power of attorney, the healthcare power of attorney, and the Advanced Healthcare Directive sets out who you would like to step in and help you take care of matters if you are incapacitated or unable to handle your own affairs anymore. All right. So let's look at the financial power of attorney. What is a financial power of attorney, and what does it do for a senior citizen? When you're younger and you've maybe had children, the financial powers of attorney and the spouse, we have banking assets. We also have social media assets that a spouse, we designate a spouse to come in and take care of. But in our senior years, we face different health crises. One of the major health issues that's affecting senior citizens today is the diagnosis of dementia or Alzheimer's. So when a person receives an initial diagnosis of Alzheimer's, or dementia, there is that progression of mental decline. And there is an inability to start handling financial matters. Okay? A financial power of attorney, you step in and you say, I name my friend or my spouse to be my financial attorney in fact, to act on my behalf, and we list all these documents, all these areas that you're asking someone to help you with, okay? And you make it durable. When you have this type of financial power of attorney and you're married, you can make the financial power of attorney go into effect immediately. And the spouse, whether you're incapacitated or not, whether you have mental decline or not, your spouse can go in and work with bank institutes, business, security agreements, expenses, digital assets, okay? Now, one of the questions that was posed to me, I will get to, it's like about spousal rights and financial powers of attorney. So I'll hold on to that just a minute. The other part is, let's say, even if you're married and you don't want the power of attorney to go into effect immediately upon your signing of the document, then what we do is we put that it only goes into effect upon incapacity. Well, one of the questions that you asked on there was, well, how is incapacity determined, all right? Incapacity is determined legally by two physicians. One could be attending, one not, but two physicians will determine if there is mental decline, if there's mental incapacity. Mental incapacity is also then kind of divided up into the mental incapacity to handle financial affairs, which is usually the first to go when a person has a dementia diagnosis, right? And then the next part of mental incapacity comes in, and it's overall can't make any life decisions. Okay, so you see that there is a spectrum or a timeline of incapacity that can occur. So let's say you or someone in your family or someone you know is diagnosed with dementia, and there's financial incapacity. And we have a financial power of attorney that springs into effect. Okay, so now we waited. You say, I don't want it to go into effect now. I want it to go into effect on incapacity. It springs, just like a spring. It springs into effect, and the attorney, in fact, steps in to your shoes and starts taking care of your financial decisions, okay? This document for senior citizens is very extensive. It covers every financial decision that you yourself could make. The only area that may be a problem is real estate. Real estate, they tend to want their own form, but if there's incapacity, the financial power of attorney for seniors does include real estate transactions. And your attorney, in fact, can step in and take care of those real estate transactions. All banking transactions. If you operate a business, the person can step in and take care of business expenses. Maybe the business needs to go through a winding down process. Maybe the business is being transferred. You have a legacy plan. Your attorney, in fact, steps in and starts handling those affairs on your behalf, okay? So that is a financial power of attorney. Without one in place, with no one named, and you are going through, or someone you know is going through incapacity, what happens is that someone else will go through and go to court and ask for conservatorship. If you have nobody named, no person that you would want to take over, or you have someone you want to take over, but you did not name anyone, you do not have a document, okay? You could end up with a person that you would never have wanted handling your financial affairs. So, having a financial power of attorney allows you right now to take charge of your financial affairs for the future and have a plan in place. One of the first questions, part of the questions in probate court for conservatorship is, are there powers of attorney? Why? Because this document, in the financial power of attorney, the person you name is also the person that you name to be a conservator if anything goes to court for conservatorship. So this document not only is important for younger people from 18 years old and up, but it's very important for our senior citizens. It gives an extra layer of protection to you. Now, one of the questions that was asked is, well, what happens if I am living with someone, but I'm not married? Can that person be an automatic power of attorney over my finances? Well, in the state of Missouri, this person, even though you live with the person, doesn't necessarily have the authority to act on your behalf. The presumption that goes with a spouse is not with the person that you live with, that you are not legally married to, all right? Well, what about you are an older person and you have a live-in and you have adult children, right? What happens if you do not appoint an attorney fact for your finances. Your adult children can go to probate court and ask for conservatorship. Okay? So this document helps you put those choices in place. Another question that was asked: what happens if I appoint a spouse and the spouse starts spending all my money? Okay. Well, financial abuse is against the law in the state of Missouri. And here's some things. If a spouse is a spendthrift, starts spending all your money and wasting your money, you'll have a successor named who can step in and try to put a stop to a spouse spending down the finances, all right? And this may happen. I mean, one spouse may have a diagnosis of mental incapacity and have that decline, and the other spouse may have a mental illness and have other issues, and so can't handle the account. So you would have someone, a successor, attorney-in-fact, step in and take care of the issue of any type of mishandling of finances. Another thing is question: what if I name a child, my adult, so I'm estimating it's an adult child, and my adult starts taking all my money for himself? Okay, again, financial abuse for elders is against the law. And if you have an adult child who is helping themselves to your money that you have for their own needs and not you, that is financial abuse and needs to be reported. Hopefully there's someone else in the family or neighbors or friends who can report it. But again, always make sure that you have a successor in place. Even if it's not a person and it's a corporate fiduciary or a CPA or another type of fiduciary that you can name to step in. Okay. Having a financial power of attorney safeguards against other people and taking your money when he or she should not take that money. All right? So the financial power of attorney, you have a successor or an attorney-in-fact and a successor named, and you also know that person is a conservator. Now, you don't want to name someone without talking to the person to be your attorney-in-fact, all right? It wouldn't do any good to name someone and then the person refuses because that person doesn't want to be your attorney-in-fact and help take care of your finances. So always talk to the person that you're wanting to name as your attorney-in-fact. And the other thing is, you want to make sure that you pick a person that you can trust with your finances. Don't pick a person just because the person is your oldest daughter or son or your closest friend, all right? The person that you choose to be your attorney-in-fact for your finances, you need to trust explicitly and feel comfortable with the fact that they know how to handle money and how to work with all the different financial situations. Okay, so I think overall, remember, financial power of attorney names your attorney-in-fact a successor. You can have it go into effect immediately, even for the spouse, or you can have it go into effect only when you're incapacitated and it springs. You can also sign a financial power of attorney that goes into effect. Let's say you're going to have major surgery and you want someone to act as that. You can come back in and revoke their authority and then have it spring into effect at another time. Financial powers of attorney, you can revoke them and you can amend if the amendment is in writing. So a financial power of attorney is a needed document, but it's also one that you revoke, you amend, and safeguards you in your senior years, meeting different health crises. So that's a wrap up of the financial power of attorney, and we'll get ready to move on to our next topic.